I know na ye collation. The system how the bar say a robust and strong fire collation. You collate 5 regions now or say a crashing.
He told us the system was strong and robust. However, after collating the results for 5 regions, the system crashed.
Results at the right time said let me challenge the charcoal. And so here on the
that was why we didn't have the results at the right time to challenge the Electoral Commission's results. And then we said we wanted to collate the figures manually. Together with a team of university students, Griffiths again failed to do a good job.
Say your man appointment or you're prepared to resign as our national chair.
Ofosu Ampofo said he was ready to step down as leader of the party if you don't appoint Griffiths as the director of IT.
The appointing director of IT. Griffiths no. Or no Akamba himself. Griffiths ne Baumia.
Akamba during the meeting mentioned that the person to be appointed as the director of IT has some underhand dealings with Vice President Baumia, and that the party has to be extremely careful in handing over its election collation mission to him.
Yeah, welcome back. This is Newsfile. It's your most authoritative news analysis platform, and here on Newsfile we put Ghana first. So, in perspective, that's the first issue we are canvassing for you about that confession, quote unquote, by Johnson Esiedun Ketia, General Secretary of the NDC, who is seeking today to become chairman of the party, and who, if he were chairman of the party at the time the NDC decided to mount the election petition, it may not have happened because they were going on an empty process, so to speak. There was no evidence to back what they were seeking to do. Is that your understanding of what has transpired as far as his conversation, which has now been made public? And for how long now you have not heard him state anything otherwise, deny or state anything or try to explain that the context or anything else is different in that statement? My guests in the studio this morning, 2 lawyers who are also authors of legal texts. Bobby Banson practices here in Accra, just saying in Accra, but practices in the jurisdiction of Ghana. And he is the author of the latest book that lawyers are excited about, Civil Litigation in the High Court of Ghana by Bobby Banson. Then we have Daniel Korang, who is also a lawyer and author, prolific author. He's authored several texts in criminal law. And right in front of him, over there, you can see those books. Also joining us is the Deputy Attorney General and Deputy Minister for Justice, Alfred Tuah-Yeboah, Mary Awalana Ada, who is Programs Manager, Ghana Integrity Initiative, the GII, Suleiman Abrahima, who's Executive Director, Media Foundation for West Africa. The three are joining us via Zoom electronically. Now, good morning, ladies and gentlemen, and welcome to Newsfile.
Morning.
Great. Good to have you. And as you have seen, I don't have something steak for you this morning because our table is packed. And to let you know, the date for the domestic debt, that the Ministry of Finance has been working on, and for which there's been some disagreement by civil society, some civil society, and also TUC, more particularly because they are greatly affected by that process. The expiration date has been extended. The Domestic Debt Exchange Program, the DDEP, has been extended to December 30, 2022. I suppose that we will all understand why this is so that the ministry can get the needed buy-in or agreement of those who are not in agreement to be able to get this properly done. And it says that it is considered, some of the development that have happened. It is taking into cognizance the festive season, and it has decided to extend the expiration date of the voluntary offer to Friday, December 30, 2022, with a completed settlement date on Friday, January 6, 2023. The extension comes on the heels of the announcement of a staff-level agreement with the IMF on the 13th of December, 2022. And that's where we heaved a sigh of relief, really huge. And thankfully, we understand that this is part of the reason the cedi appears to begin to whip the dollar. Is it really whipping the dollar? But something is really happening. Within just, 10 days or less, the cedi has seen such a tremendous appreciation. And all of us, are just keeping our fingers crossed that it will be like this, and that the cedi could get to, the dollar could get to 5 cedis, by the end of the month or sometime soon. And then the prayer and appeal to everybody else is that let's look at the situation and begin to let it reflect in the things we are selling and everything that we do in our transactions. The kinky price may still go back to 2 cedis, perhaps. The transport union has also reduced their transport fares. It may not be as significant, but it is important. So this is for all of our attention. The date of the expiration has been extended. This is significant. Now, having introduced my guest, let's go to begin the very first discussion that we have. If you followed the newspapers, and I'm presently looking at one of them, the Daily Graphic, it reported on the 13th of December, 2022 by Emmanuel Ebo-Hoxton that the heading is "Court, quote unquote, frees defunct Capital Bank founder William Ato Essien." And it tells a story that William Ato Essien, the founder of the defunct Capital Bank, who was standing trial for stealing 192.5 million of depositors' funds, has avoided a custodial sentence. 192 has avoided a custodial sentence. Essien avoided prison today, that's December 13, 2022, after the court, presided over by Justice Eric Che Bafo, who is a Court of Appeal justice with additional responsibility, accepted an agreement between him, that is Essien, and the prosecution, that's the State Attorney General, for Essien to pay 90 million as restitution to the state. As part of the agreement, Essien pleaded guilty to 16 counts of stealing and money laundering and was accordingly convicted. Then, Essien, who was standing trial with Fitzgerald Odonko, a former MD of Capital Bank, and Tete Nete, the CEO of a company said to be controlled by Essien, were acquitted and discharged after they were found not guilty. As part of the agreement, Essien, who pleaded guilty to stealing 192.5 million of depositors' funds, has already paid 30 million to the state and will pay the remaining 60 million by the end of 2023. This is to be paid in 3 installments of 20 million each. The presiding judge accepted the agreement pursuant to Section 35, very famous now, of the Courts Act 1993, which allows accused persons standing trial for causing financial loss to the state to pay the money and possibly avoid a custodial sentence. I read this to you before I get to my guest. per the orders of the court, in the event SN defaults in paying the money by the exact timelines, first on April 28, 2023, second on August 31, and last on December 15, 2023, he will be sentenced to prison. Please mark that. He will be sentenced to prison. Justice Chebafor also ordered that by virtue of pleading guilty, SN cannot be appointed as a director of any bank or any financial institution pursuant to the Banking and Specialized Deposit-Taking Institutions Act 2016. The judge also ordered the registrar of the court to seize the passport of SN until the convict finished paying the money. Justice Chebafor, who initially rejected the agreement, accepted it today, that was the 13th of December, after it was explained to him that the state had already recovered 101.2 million. I think it bears repeating and emphasis that the Attorney General told the court that the state had already recovered 101.2 million of the 192.5 million, with the remaining amount being 92.5 million. The remaining amount being 92.5 million. Let's not end it there because it may obfuscate the issues. So let's continue. Also, it came out that an amount of 35 million was repeated twice on the charge sheet, meaning SN actually has 57.5 million to pay. He actually has 57.5 million to pay, meaning the 90 million being paid by him was in excess of 32 million, which will be interest on the amount to the state. Justice Chebafor accepted the agreement after listening to the submissions from Deputy Attorney General Alfred Tuah and lawyer for SN Thaddeus Sorry. Thank you. Now, there's been a huge backlash in comparing what has happened to poor, thieves, plantain thieves, and what happens to them. Why is it that they also cannot get the opportunity of not going to jail, but simply returning what they have stolen and perhaps make compensation and go free? Let's begin with Bobby. What's your... Yes, Bobby Banson, let's begin with you. Yes, what do you say? And I have read even lawyers, some lawyers, disagree with this, that this is not good, this is not right, it should not be done. What do you say?
Well, good morning to you and your listeners and viewers. I have quite a number of things to say.
Yes.
First, nobody would dispute the fact that the state has the right to enter into such arrangements with the accused person. Nobody would also dispute the fact that the court has the jurisdiction to either accept the arrangement or reject the arrangement in the terms of Section 35 of the Courts Act. However, I want to state also that from my understanding of the provisions of the Courts Act and the Criminal Procedure Code, if a court finds an accused person guilty for offenses relating to stealing, what have you, the fact that the court may impose custodial sentences does not mean the court doesn't have the jurisdiction to additionally order restitution. And so it is not as if it's either you refund the money or you go to jail. They are not mutually exclusive. A court has the jurisdiction to impose custodial sentence and in addition order that you refund the money.
This is what Ghanaians, as we read, many or most would have preferred. That you convict and then you make the person pay.
Yes, and I agree.
You sentence
with that
and make the
approach.
person pay.
The reason is that the aim of criminal proceedings or
criminal justice
is not only restitution. There is also the deterrent element there. And so if you have the states that made a lot of political meal out of the banking crisis, saying that certain persons, because the previous administration were lax, took advantage of it, and so they would have to make sure persons pay for it. And what you have done is to choose only the restitutionary path. It means that you have not served the deterrent part. You have not. The other thing I would want to say, which I found very interesting, you see, at the time they entered into this agreement, the trial had ended. Written submissions had been filed. The judge had adjourned to give judgment. Now, when the judge rejected the first, or when they first came up with the agreement and the judge rejected, because obviously he didn't understand, this so-called explanation, will it be reflected in the charge sheet? The facts that were laid? Those are my questions, because at the time they were prosecuting the gentleman, they never stated anywhere, I don't recall it in the charge sheet or in the particulars of offense or the facts of the case that they presented, that they had recovered 102 million. I don't think it was part of the record before the judge adjourned for judgment. Now coming to explain that, oh, we are doing X amount because 35 is interest.
Okay.
Would they have to go and amend, or did they amend the charge sheet and the facts?
Okay.
Now they, oh, sorry.
I will bring in the AG to help with the facts, because some of us know the facts to a certain extent, that I think that you need to know them. But substantively, when you say you agree with the sentiment that the best option, particularly in this very significant trial, is to both convict and sentence custodially, and then, also ask for a refund, or as it were, for recovery of the money. Are you saying that under the Section 35 of the Courts Act that they went under law, the judge had the discretion to send people to jail and also ask that money should be refunded?
It may not have been mentioned in the Section 35 that you would either choose the custodial or you refund. So Section 35 provides the arrangement that the state may and the judge may. However, the provision is the Criminal Procedure Code, I'm very certain about it, allows for both. And as long as they are not inconsistent with each other, I do not think that they should be treated as being mutually exclusive. Okay. Because it will not be the first time. Because we had a similar situation where
Section 35, particularly subsection, I think we should read subsection 4 and 5. It says, if the offer is acceptable to the prosecution, the prosecutor shall, in the presence of the accused, inform the court, which shall consider if the offer of compensation or restitution and reparation is satisfactory. These are the level of the prosecution. Then he moves on to bring in the judge. 5, where the court considers the offer to be satisfactory, the court shall accept a plea of guilty from the accused and convict the accused on his own plea, and in lieu of passing sentence on the accused, make an order for the accused to pay compensation or make restitution and reparation.
Yes. And so that is what I'm saying, that if you come under this section, instead of passing the custodial sentence, you may. It used the word may.
No.
It said if it is...
The court shall accept a plea of guilty from the accused and convict the accused on his own plea, and in lieu of passing sentence on the accused, make an order for the accused to pay compensation or make restitution and reparation.
Yes. So the point I am making is that if the judge sees that, okay, the agreement that the parties have made is one that I think is fair, looking at the circumstances of the case, and would decide to go under this session, I still think that looking at the circumstances of the case, the judge should have exercised his discretion for the purposes of the deterrence and the political meal that had been made out of this matter. Even if Samson, it is 2 weeks, 1 week, 1 month. It's not personal. It's not as if we have personal matters against Mr. Atuasia. But we all understand the background to this case, how he vehemently denied involvement in all these allegations. And towards the end of it, this is what has come out of it. It's only fair that there is something that will show that the state is interested in justice in all fronts. And also because you said you'll be bringing the Attorney General, if we could, or if he could educate on the nature of the charges involving the other 2 persons. Because it's also very interesting, the legal implications of how one person is found guilty, the others, whether it's abetment, conspiracy, the facts that were levied, and then they were not found guilty. So that we all understand everything that had gone on in that matter.
Right. So I'm coming to Daniel now, but the first accused, as we understand, would have been acquitted of all the charges he was facing with the 3rd accused person and the 2nd accused person. So there were charges that were sort of, if you like, joint. So acquitted of all those.
Okay.
Then the 3rd accused person was only charged with 6 inchoate offenses. I think what the criminal law teacher will tell us, and both of them, they write and they teach, that once the accused is acquitted and discharged, okay, then automatically it goes to say that the first accused was also discharged on those charges.
Yes,
right. Now, do you agree, first of all, or what do you have to say about the outcome?
Thank you very much. Good morning to your viewers. I do not entirely agree with my good friend. You see, there are arrangements within the criminal procedure. And once you accept a particular arrangement, you must as well abide by the principles in there. Generally, an accused person may be sentenced to prison, as well as be given an opportunity to make reparation and restitution, that is, return stolen goods or stolen money. But the public must appreciate that the case under reference is not an ordinary case of stealing. You know, when you look at Section 35 of the Courts Act, it does not talk about an ordinary stealing or ordinary case of fraud. It talks about a criminal offense that involves economic loss to the state. And I think this particular element is missing in the public discussions. Because when somebody steals a goat belonging to a farmer, or somebody steals money belonging to a community bank, this is a case of stealing, but certainly not one that involves financial loss to the state. And so the regime under Section 35 is that when the offense involves economic loss to Ghana as a state, that is where that section can be triggered.
Is that not why the punishment must be heavy?
Well, if we have to criticize, we don't need to criticize the Attorney General. We don't need to criticize the court. We need to criticize Parliament for passing this law. The law is that when a case like this comes to the court, the accused person has the right to make an offer of reparation and compensation. And it is within the Attorney General's discretion to accept that offer. And further, it is within the discretion of the court to also accept that offer. And when that offer has been accepted by the court, or the court finds it satisfactory, there is no further option for the court than to convict the accused on his own plea of guilty, and then make an order that do reparation or pay compensation or make restitution. In lieu, you see, you read in lieu means that
in place of
custodial sentence. And let me say that when a court proceeds under Section 35, the court will not have another option to impose custodial sentence.
The court doesn't have a discretion.
At all. There's no discretion.
The judge couldn't have said, look, this situation, Ghanaians, because they are actually, right now, you and I,
yes,
we are paying for the bank collapse.
That is it.
Because there's a levy on it in our banking, transactions. So the court will say, looking at what is going on, yes, you are paying 57.5 million,
yes,
which is the actual money that we have come to agree is lost, which you must pay. And then you are making restitution of a little over 30 million.
Yes.
So that's the compensation you are giving to the state, a little over 30 million.
Yes.
Nonetheless, we still feel that you must go to jail somehow. The judge couldn't have done that.
Not under this provision. You see, what we must understand is that in modern legal systems, the traditional methods of punishment are gradually being done away with. And what we call plea bargaining is also speedily and rapidly taking center stage. Plea bargaining means that we think that we should engage accused persons in a manner that ensures that they remedy the mess that they cause by their actions. So here is an accused person who has caused massive financial loss to Ghana. Let's assume that he did not take advantage of Section 35. He was tried under the ordinary rules of criminal procedure and was thrown into jail for, say, 50 years to rot there and to die there. Now, what would Ghana have gained?
Would have gained deterrence to people who may be thinking they want to do same to the country next time.
My view is that custodial sentence does not deter as we think it does. Now, there is prison, do I say prison centers, or there are prisons in almost every capital in Ghana. You go to Sunyani, we have prison, and in other districts, you have prison, minor ones. We see prisoners every time on the street sweeping and doing work for people that are getting paid. But do these things really deter? Of course, we have general deterrence and we have specific deterrence, which means that the criminal involved will be deterred some way, somehow. And the public might also fear that they to commit a crime. But the point that we should understand in this discussion is that this is not an ordinary crime. It is a crime involving the economic interest of Ghana. And it is important that we emphasize recovery than custodial sentence. Because if we put ASEAN...
No, they are saying that you could get both.
We cannot get both.
Why not?
The reason is that the regime under Section 35
that you can decide not to go under Section 35.
Well,
and rather say, I will prosecute to the end. I will not accept any agreement. Prosecute to the end because I'm sure I'll get you convicted.
Yes.
And I'll get you thrown into jail. And then there will be an order for the state to get its money back.
Samson, let me ask this question. If the Attorney General had gone under the ordinary rules of criminal procedure to get conviction and a custodial sentence and a further order of restitution and reparation. Now, we know that ordinarily, imprisonment curtails the movement of the person involved. It really, puts him in a situation that he cannot do any economic activity. So it does not really sit well with reason to say that ASEAN go to jail for 25, 30, 40 years and make reparation, return this our money.
Recovery.
Where
can only order recovery. Then.
Yes. Where is a prisoner going to make recovery?
The state should find how to get the money back.
Assuming that ASEAN must be out to go about some economic activities and make some rounds to bring back the money. Now, when he is thrown into jail, how does he do that? So when I appear before any court in criminal cases involving loss of property and money, and there is a need or an interest of recovery and restitution, my prayer is always that when you get this person into jail and he is languishing in there, is it family members or friends or who are supposed to make the reparation? So yes, I understand Ghanaians. I understand the backlash. But what the public must understand is that because of the economic interest nature of this particular crime. That is why we have this provision in our laws. And so when the Attorney General took advantage of this very provision, in my view, they didn't err.
Okay. Before I go to my other guest, and I'm doing something deliberately, I'll bring in the Deputy Attorney General. The last time we discussed it, we spoke to him first at length, and he explained, gave us the facts and the misconceptions about how much exactly was owed and everything. He explained all of that. Now, I see that as Bobby spoke, he was referencing the Criminal and Other Offences Procedure Amendment Act 2022, Act 1079, which the President assented into law very recently, July 2022. When you were saying the judge, for as long as this does not contravene or does not depart from Section 32, he could have also gone under 35. He could have also gone under this law, or the Attorney General could have rather gone under this law, where you make the offender plead to a lesser offense.
Yes.
Then you get some money back, and then still get jail.
Yes, that makes a lot of sense. You see, I started by saying that the criminal procedure is a very big arrangement that has within it several other minor arrangements. One of them is the plea bargaining, as we have enacted.
And you were part of this process?
Yes, I was part of the parliamentary workshop at Koforidua.
Okay.
Now, this plea bargaining arrangement enables us to have reparation and custodial sentence. That is one arrangement. And Section 35 of the Courts Act is another form of plea bargaining arrangement that gives us reparation and compensation without a custodial sentence. The same arrangement is repeated in Section 71 of the Office of the Special Prosecutors Act. Now, we have these options there. It is not the Attorney General who triggers the discussions under any of these. It is the accused person who says that I want to go under the Plea Bargaining Act, or go under Section 35, or allow the trial to proceed under the ordinary rules. Now that accused person comes in to say that this is what I want. And the Attorney General and his people think that in the interest of Ghana recovering the money, why don't you go here? Because I've already said that when a person is incarcerated and you still expect that person to make reparation, sometimes you realize that you are just not, going to end anywhere. Of course, if the judge had rejected the plea negotiation or agreement and had said that, well, let's allow the trial to go on. If you are convicted, I have the power and discretion to make orders for reparation and compensation, as well as sending you to jail. Now, I think in this situation, the jail element that is missing takes away our view of deterrence.
Yeah. So the question others have asked, and I'm going to my other guest, and Deputy Attorney General, please, this is deliberate. Just hang in there. I can imagine that you are listening and you feel that some of the facts are not as accurate and you want to come in, but just hold on there. I want to hear our other guests and then come to you. If the purpose is to recover money which is important to us, and that, as you said, the criminal justice process, the world over, is beginning to gravitate towards finding a way to recover money, to compensate, as it were, restore people, rather than sending them to jail and the state feeding them. And in Ghana, they don't feed them as much. They are always fighting because of food, and they don't even have a good place to sleep.
Yes.
Now, what will you say to the fact that when you guys were working on the Plea Bargaining Act, you exempted certain offenses for which people must not be allowed to plea bargain?
Yes.
And some will say, if you say something like defilement, when people get defiled, sometimes they are poor people who get defiled. Maybe they would have agreed that they will get, maybe it's a rich person who has defiled a poor person. They will rather get good money from them.
Or even let the lady marry.
You know, they would rather get good money from them instead of you throwing the person into jail. But you guys agreed and ended up with a law that says you can't negotiate on these matters. Yes. These ones there will try and put you in jail. Treason or high treason, high crime, rape, defilement, genocide, robbery, kidnapping, murder, attempted murder, abduction, piracy, hijacking, and other offenses related to public elections. Yes. Now, let me go to Mary. I don't know, do you feel the same as this section of Ghanaians who feel this is not good enough? Taking the 57.5 million, which is the actual money that the records show that he should have paid, or quote unquote, that is the money that is stolen, quote unquote, and then pay 30 something million as compensation and then go free.
Thank you very much, Samson. Good morning, and good morning to my other panel. I would want to first of all say that all the submissions that have been made so far make sense. Yes, it is indeed true that the Attorney General has the right for the law to do what they have done. It's also true that the court has the right to do what it has done. But the question we must be asking ourselves is the fact that should people in public office, whether it's public or private, who have opportunity, go ahead and steal, and then after stealing, they decide that, okay, I have stolen, so allow me to pay back, and then I get away with it, and the state agrees to do that. I think in summary, that is what has happened. Let me say again that I do not know this gentleman personally to have any ill motive against him, but to say and contextualize that the fight against graft and corruption in our state has been stated to be one of the weakest links to our development. Again, we have seen various audits done and reviews, particularly on the UNCAD, that has shown that our sanctioning regime is very weak. So the people of Ghana would have appreciated that when the opportunity availed itself, the Attorney General's office would have pursued this to the latter to ensure that we are generating or gathering some trust that we are interested in fighting corruption as we proclaim. Again, let me say that when we say we are deterring people, you have said it, that when people steal goods, when people offend, the minor one, we are quick to sanction them, and the sanctioning is punitive. So the question I'm asking is this punitive enough? If the monies which were stolen, perhaps we haven't done some calculation on this, the interest, if he had invested this in treasury bills, would he have gotten the 30 million we are saying is the interest which is added to the 50 something to make it 90? Is that enough? Are we not sending the message out there that people who have opportunity can continue to do what they want and just get away with it? Because the state is not interested in pursuing this to the latter to ensure that the right thing is done. I believe for us in civil society, we think that this was a fine opportunity for the Attorney General to demonstrate that this fight against graft, the fight against the blatant stealing of our public resources, is one they intend to pursue to a very good conclusion, to let the citizens know that we can trust this system again. But if we see these things happening, then we are beginning to think that we just want to enter into plea bargains and let people get away. They would cash all the stolen assets and then go back to enjoy them.
Yeah.
So
Mary,
when you say that, shouldn't we have pursued both? I believe that is the question for the Deputy Attorney General to answer to the people of Ghana, because we believe that we should have pursued both.
Right. So I was going to ask you, we take inspiration from, developed countries like the US and the rest of them. As we speak now in the US, an ex-Trump organization chief finance officer pleaded guilty to 15 felonies. 15 felonies, not small offenses. Now, if the organization was found guilty, they could have been paying back taxes, and then they will be fined. But in the circumstances of he pleading guilty to these charges, he got the state, or as it were, he got them to pay $2 million. In exchange, he got 5 months sentence in jail. But for the plea bargaining situation, they would have gone through a whole trial, and perhaps he could have gotten the best of lawyers, and he may not have been found guilty. What do you say about that kind of thing that informs these kinds of law? And Daniel was saying, don't blame the Attorney General, don't blame the court, blame the law, Parliament, and seek to refine the law if you want.
Yes, Samson, we would pursue that as we go along. It's also a fact that sometimes when these laws are made, we look at our context and then put in place some of these. And so I would begin by saying that the context within which what you are talking about was done is different from ours. And even there was a custodial sentence. So for me, in this context where the trust is so low, and then we know that there are not many of such instances that have happened in the past. This was a novel for us to ensure that we did the right thing. So if you are comparing America to Ghana, even though you lawyers would say you are comparing cases, but we know for a fact that our context, the fight against corruption and graft, is very different. We have unique circumstances under which we are working. Okay. And so we should be looking at our context to then determine what we are doing for this system.
Great.
And in our context, we need more punitive sanctions to
than the money. Thank you.
People are deterred.
Okay. Than the money, or we need both. That's the argument.
We need both. Okay. We need both.
Yeah, but where the Attorney General makes the decision that you can't get both. You can't eat your cake and have it.
But that is not possible. The Attorney General knows very well that there are other laws he could have also utilized. And so to go in for one at the expense of the other, perhaps maybe he knows his capacity issues. I cannot fault him for that. Perhaps he believes that he wants to do the quick thing to get the money. But the citizens of Ghana believe that he could have done more because we trust the AG. We have seen him at work, and we know that he could have done this. Okay. So for this, we believe it's a missed opportunity.
What do you say to them when they? What do you say to them when they tell you that when this case started in 2017, thereabout, is it? The law we are talking about now, that would have given the Attorney General the opportunity to ask that, okay, pay this amount of money, maybe we can withdraw some of the charges, or we'll make you plead to lesser charges, and then you pay the amount of money, and then you go to jail for a short time, so to speak. That law was not made at the time. So they started the bargaining from the very beginning of the case. So this law was not even then in the view then. What would you say to that?
Unfortunately, for some of us, if it wasn't there, it means it couldn't have been used. But then I am very sure that for you lawyers, you would have found something else to use.
No, in our jurisdiction now, you couldn't have found something else.
But we know in the past we have had cases, even though it's not similar to this, which we have gotten some conclusions. So we have some challenges. But then we also know that there is always a way if there is a will. And so for me, I believe that if there was the will to continue, there would have been a way to circumvent all this.
Now, finally, and some 30 seconds, does it make any difference to you that whilst the criminal prosecution was going on, there was also a civil case that seeks to recover the monies specific to those that some of the monies went into their hands? So I think that civil case has as many as 16 or 18 defendants, including Atuasian.
For me, if it did not take away attention and then capacity from the AG's office, then it doesn't make a difference. But if it took away the attention and capacity as well, it does. Perhaps maybe we should have waited to have a conclusion to the criminal case, and then we go on to the civil to ensure that we could do more. But then at this stage, perhaps the Attorney General has his reasoning for pursuing both at the same time.
All right, thank you. Now let's go to Suleimana. Let's go to Suleimana Brahima. And Sule, before you come in, just a minute, Bobby Banson wants to make some small input.
Yes, just small. I was making reference to Section 148 of the Criminal Procedure
Section
Act.
148.
Yes, I see there that there's a limit. So the law there used the word compensation. So in that instance, then the court can pass the custodial sentence together with ask or order the accused person to pay compensation. But there, the amount to be paid is limited. So I believe that the judge may have weighed that provision, because that was what I was seeking to push. Okay. But the amount there is very limited. And so then that
is where the popular view is that's the education you are seeking to be. The popular view is saying that you could have gotten your money and still put the person in jail. You are saying what exactly?
That you could not have gotten all the money that you are asking for if you want to go under Section 148 of the Criminal Procedure Act. So that the court would then pass the custodial sentence, but then order what is called compensation to be paid to the person that have been injured, which in this case will be the state. But the amount to be paid is stated at 10 million cedis.
In this law?
In this law. That is what I was saying, that, so like you said, in the criminal jurisprudence, there are so many aspects of the law that will promote this kind of arrangement. But I believe that if you look at the
10 million cedis, let's be careful. You are reading, we don't know.
Oh, 10 million
if this is not if this is not the green book,
yes,
where Justice Crabb has revised, it could show that it's no longer 10 million.
Yes, it could show a lesser amount, I'm sure.
It could show a bigger amount, right?
Oh, a bigger amount, yeah.
Yes.
Yeah, they made it a bigger amount.
Okay, now let's go to, we'll try and check what the Green Book says. We have what we call the Green Book. The Green Book is Ghanaian laws that the state has given power or gave power to the Law Reform Commission, which was at the time headed by Justice V.C.R.A.C. Crabb. Of blessed memory, and they were reviewing our laws because there were things that were antiquated, there were things that were completely lost. So they changed things from time to time. As you can see, it's 10 million there, which is maximum. But if you see Justice Crabb, I suspect if you read the Green Book, he would push it up because 10 million, 1960 cannot be the same thing. Right. Now, Sule, let's hear you. So across the table here, you have heard Bobby Banson, you have heard Mary, who agree with the popular point of view, except the latest revision that Bobby has brought in. Where do you stand?
Well, Samson, I think I'm really tilted towards what you call the popular view. To start with, we've had instances where politicians have gone to jail for causing financial loss, whether or not at the time the opportunity to do plea bargain or what has been used in the current situation was available or not is another matter.
Yeah, it was available. It was available.
So we can talk about Malam Issa going to jail for causing financial loss.
Yes, this law is 1993.
Right. George Sipayanki, Dan Abudapi, Ibrahim Adam, and all those people went to jail for causing financial loss to the state. The question then you ask is, was it a case that the lawyers for these people were not interested in the possibility of, plea bargain or paying back the money, and that is why they went to jail? Now, listening to the conversation, there was a point, one of the panelists made the point that, look, at some point, the accused person says, this is what I want. And I guess the question to then ask is, what does the Attorney General want? Because I don't believe that what the accused person says I want must be what should be acceded to.
And in fact, the accused person didn't get what he wanted. That is why the agreement process, the negotiation, started at the very beginning of the case and yet could not be concluded until by the time they were giving judgment. Initially, the accused person, as the records show, was admitting to accept only 25 million, which was what he called the promotion money he had taken as duly entitled for business promotion and other things. The Attorney General refused. They made a second attempt. They refused until the Attorney General pushed it and got 90 million.
Right. So when it is argued that you don't blame the AG, you don't blame the judge, but you blame Parliament, I guess these revelations gives the indication that the AG could have also gotten or pursued it in a way that he thinks would give justice to the people of Ghana. Now, I'm not a lawyer, but quite often I read pieces of legislation that says, if found guilty, you can be sentenced to a fine of that penalty unit or not exceeding this, or a prison term not exceeding this. And I always see or both. And I suppose there is a reason why there will always be either this or that or both. And again, as a non-lawyer, I would want to believe that there have been occasions where that particular provision in terms of sentencing somebody to suffer both in terms of a fine and imprisonment can be possible. And so looking at the situation in broad terms, what I ask myself is, where is the punishment? Because if the person has committed a crime and has admitted to committing the crime, and all that we are told that the person must do is to refund the money with interest. Samson, you and I, when we go for a bank loan, we pay interest. Do we see the bank, the interest as a source of punishment? I don't think so. So to take money belonging to the state, inappropriately, or to steal it, use it for your own businesses, make profit out of it, and then when you are caught, you admit to the guilt, and then what you do is basically to refund the money. I hear people say the 30-something million is compensation, but I think if you read it, it talks of it as interest that haven't been accrued on the money. So if all that the person did or the person is being asked to do is to refund the money with interest, then really it's almost like it's fine to steal. If you are caught, you refund the money with interest. If you are not caught, then you can go scot-free. And so the question that I'm asking is, where then is the punishment? If all that the person is suffering, in fact, it's not even suffering, is to refund the money with some interest.
Right.
Therefore, where is even a fine for committing that crime? If it was the case that, okay, you pay the money with this interest, and on top of that, you are being fined to pay this amount for committing that crime, then we would see some sense of punishment in that. And
Sule, to help you with the law, our law on money laundering, because one of the offenses that he was accused of, or they were accused of, was money laundering. Section 4 speaks about penalty for money laundering. And it says a person who contravenes sections 1, 2, or 3 commits an offense and is liable on summary conviction 2 and those sections are about money laundering. 2A, a fine of not less than 100% and not more than 500% of the proceeds of money laundering in the case of an individual. So, do you get that?
Yes.
So that the state could get the accused person to pay a fine of not less than 100% and not more than 500% of the proceeds of the money laundered if the person is an individual. It has a different permutation if it is a company. Then it says a term of imprisonment of not less than 12 months and not more than 10 years. So you are looking at maximum 10 years. So I'm saying this to what you were saying, to a fine, or in default of the fine, you go to prison, or both. So you could have gotten that from this provision.
Exactly.
And then it says both the fine and the term of imprisonment, or a fine of not less than 300% of the proceeds of money laundering in the case of a corporate entity. But what you are being told is that when you get such a sentence, and like Kofi Bento said the last time we discussed this issue, there are some people who will boldly say, look, I will not even go for anything. I'll just keep quiet, go through the trial. You convict me, I go and serve my jail term, I come back and enjoy my booty. Or I don't have to come back. I make sure my family and people that need to enjoy are enjoying. You know, and the state may be asked to recover the money whilst you are in prison. But they can't find your asset, because by the time you are being jailed, the asset has, they will say mogrified into various different people. You can't trace it to get it for the state. So all you would have gotten is a person in jail. What do you say to that?
Well, in this case, I think we could have really gotten more than that. Because,
how? Explain.
As I said, one, so the person, based on what we've read, the total amount was 192 million or so. The state says it had already recovered about 102 million, leaving a balance of about 90. Then we are told, oh, there was some repetition of a certain amount. And that amount added is actually the interest that we are asking the person to pay on the money. So all that put together, the person is supposed to pay 60 million or so between now and the end of 2023.
90 million.
Sorry, 90 million between now and the end of 2023.
Yes.
And I'm saying that, therefore, where is the punishment? Because that's exactly what the person took. And you are basically asking the person that if you had gone for this money as loan, you would have paid interest anyway. So pay the money back and pay the interest, and that's it. And I'm asking, is that deterrent enough? Why wouldn't this be a motivation for others who would say, oh, okay, so if I go through these processes and I'm able to make some 200 million, well, I try to keep it. If eventually I am charged, I go under this provision. And then if it is accepted, all I do is to pay with the interest. And I would have made more than the interest that I'll be asked to pay anyway. So I really struggle to find how this can be a deterrent in preventing crime from being committed against, our state.
Okay, so now, the question I ask you is, do you prefer to get the money and get that bit of interest on it, if it's not as much interest as you desire, or you prefer to just throw the person into jail and then you get nothing? And you would have also spent state resources doing the prosecution, and then the person goes to jail. It's your state, it's your money again that has to take care of them.
So the point I'm making is this: if I'm charged to the court tomorrow and I'm found guilty, I'll be fined. So first of all, having been asked to refund the money, because they're refunding the money with interest is a given. That one is something that you took. There could have been a fine, a substantial fine to serve as a deterrent, in default of which you go to prison. That's option one. Option two, again, speaking as a non-lawyer, is whether or not we could have had a situation where we say, okay, you go in for 40 years or for 35 years. But if you would want to refund the money with the interest, then this is reduced to 2 years imprisonment. And there are some people that I know that even a day in prison, if I would pay or if I would commit whatever to be able to avoid that, I would do that. All that I'm saying is people have gone to jail for causing financial loss to the state.
Right.
And therefore, if others are going through a certain provision in order for the state to have the money back, we should see some semblance of a punishment that will serve as a deterrent. But what we've done is to indicate that, look, yes, you can take the money. The consequence of it is that you refund with interest. That's all.
Okay.
And I don't think that is really helpful.
Yes, but the lawyers are explaining something to you that is inconsequential for you, that the manner in which you wanted it was not available. That law they could have used was not even available at the start of when they were doing all of this. And that the law that they have used to get you some money and some interest does not allow the judge to do otherwise. So that's why Daniel says, then go to Parliament and look at the law. Then the Attorney General have also been explaining and asking, why is this popular view refusing to take account of the fact of the punishment that has already happened by way of the conviction? Because if you are a convict, you are a convict. An ex-convict, you are a convict. In this case, you can't even, and the judge had to repeat those things, even though it was not necessary for the judge to repeat them. The law says, if you are doing this kind of business or you have been convicted, you can't be a director of a bank anymore. And then a conviction on you has its own consequences. All that is not sufficient.
Well, I don't think so. And if it is indeed the cause of the law, then we actually need to look at the law, because the plantain thief or the 1,000 CD thief who goes to jail for 5 years or 6 years or whatever would be happy if all he suffers is the conviction tag.
Right.
You know, pay the 1,000 and then go home, you are a convict.
Okay. All right. Now let me go to the Deputy Attorney General and Deputy Minister for Justice. But Daniel said one small input quickly in 1 minute.
Yeah, thank you very much, Samson. This conversation is really important, but a very dicey one. Dicey in the sense that we know that there is something we call justice according to popular view and justice according to law. You see, when you are making legal argument in public, you are very likely to hit a rock, because you might know that, or you might see that you are saying what the law says, but the popular view might not sit well with what you are saying. And that is exactly what we have now. We know that the law is not logic. Sometimes law doesn't make sense, but it is the law as we know it. So what I want to say is that there is something we call prosecutorial discretion. What it means is that the Attorney General has a discretion to do so many things within the confines of the law. Sometimes when you send a person to do one thing, and that person can do that thing in 3 or 4 ways, 4 different ways, you shouldn't blame the person when he adopts the process or the approach that you may not have adopted. I don't know if that is clear.
Okay.
So the Attorney General had several options to approach this case. And in their best of views, they chose one method. That is why my argument is not that we have to condone corruption. No. My argument is that what has transpired is clearly within the confines of the law. So that if the public or members of the public are not comfortable, we should be careful in shifting blames. We should rather kind of look at how we can change the law. I am clearly of the opinion that Ghanaians are not happy and comfortable with the law. And so what must happen? You don't blame the law enforcer. You blame the lawmaker. So that we see if we can change it.
Right. Thank you. Alfred Chiayebua, thank you for your patience. And this is what I wanted you to consume before you come in and make your submissions. You have heard across the table, and you can tell what the popular sentiments are as far as this outcome is concerned.
Well, thank you very much, Samson. And then let me also extend my greetings to the other panelists. Now, what we are doing now is what I call post facto arguments. Why is it post facto arguments? We are assuming that Atwesian was guilty at the time that he even made that offer. So the court was by all means going to convict him. That's the assumption. Then you also look at people also having the opinion that even if Atwesian was going to be convicted by the court, automatically he was going to be sentenced into prison. That assumption is also quite dangerous. Because a judge sitting in a case like this, which is a second-degree felony, may even choose not to imprison the accused if he finds him guilty. It's possible. It's also possible that the judge will have found him not guilty. So now that we know the facts that he has pleaded guilty, that's why we are seeking to roll it back. To say, oh, we ought not to have accepted it. Because had it not been the fact that we went through this process, he wouldn't have accepted his guilt. He wouldn't have admitted owing or taken 27.5 or 57.5 million Ghana cedis. So it's after the fact that we think that people are making the argument, oh no, but let me come back to the main issues. Before I even come to the main issues, somewhere in the 70s, I'll be very snappy, but I'll resolve most of the issues. So somewhere in the 70s, this gentleman in Ghana by name Ohinijan, a legal practitioner in Sunyani, he was accused of murder. In the course of the trial, the state agreed with the prosecution agreed with the counsel for that accused person for him to plead guilty to manslaughter. The state accepted it, and there was a project like this one in the 70s. But that law is still in my books. And we've been using that law up to date. After that, advantage of it on many occasions in my practice as a private practitioner. So I'm not surprised that we are having this kind of discussion. It happened in the 70s. Now there's an existing law. We are trying to also make sure that that law also works. There's an uproar.
This is a 1993 law.
Yes, 93. If we think that law has outlived its usefulness, what do? Let's go back to Parliament for Parliament to amend it. But so far as we go under the ambit of Section 35, and so far as the judge is satisfied with whatever arrangement is made under Section 35, that judge has no other option than to spare the accused person sentence. And I'm saying it's considered sentence, sparing him sentence. Because in sentencing him in the future, if he breaches the agreement, a judge may say, fine, I think you've breached, but I'm giving you 1 day. I'm giving you 5 hours. I'm asking you to pay a fine. But the argument that the research has been that automatically, if you are convicted for stealing, you are going to prison.
Okay, so from what you are suggesting here, it will appear that this can be said to be suspended sentence. That is, until he has paid all the money, he's still a candidate potentially for sentence.
Exactly. Now there's that kind of suspension. If he breaches the agreement, the judge go ahead to sentence him. The judge will look at the discretion that he has from 0 up to 25 and do whatever he's supposed to do. Now, my brother Bobby made this issue about deterrence. I think for a very long time, the argument has been that litigation is a zero-sum game. Zero-sum game because it's either you win or you lose. So I take you to court, it's either I win for you to go to prison or I lose so that you get back home. We have moved on. Now, we have what we call a positive sum game. And that's the reason we have the plea bargain. And that's the reason why we have the Section 35. A situation where we are seeking to make sure that both the state and the accused person come to a certain point. And that's what we did. In terms of the amount, you've explained, 57.5 million Ghana cedis was the amount that Atwesian accepted. if you read section 35(1), it talks about compensation or restitution and reparation. Because we wanted to make restitution and reparation, we decided not to go on the side of compensation. So that's the first point, that we did this one with a very clear mind. Now, if we move in again, the second accused person who was acquitted and discharged, he was also charged with an amount of 30 million, for stealing with an amount of 30 million Ghana cedis. Stealing. He was also charged with some aspect of money laundering. He was acquitted and discharged. The state earned 0. What was the guarantee that Atuesent was not going to have the same kind of judgment? It was possible. He could have won his case, the state would have earned 0. Or, if you look at the 23 counts, the 90 million is not just one count. Some of them 5 million, some of them 2 million, some of them 3 million. It's possible that the court would have said, oh, after looking through everything, I'm convicting of counts A, B, C, but C, D, E, I'm freeing you. The amount could have even reduced further, even if he was guilty.
Was it the court's view that the 25 million or 27, the money for business promotion, was it the court's view that he didn't do anything wrong in that regard because the law that has been passed that prohibits that conduct was passed later in time? They had received the money, and what he felt he was entitled, he was actually entitled, so to speak. But it was the Banks and Deposit Taking Act was passed later in time, and therefore he didn't do anything wrong with that, because our laws do not allow retrospective or retroactivity.
Unfortunately, the judge didn't get opportunity even to expound on that aspect of the law because of the plea bargain, what we had.
Okay.
But upon listening to the judge, one of the accused persons was charged with abetment with respect to that 27.5. That person was acquitted and discharged. So, Counsel, you know how it would have been.
Yeah. So they were jointly standing on that charge.
Yes.
So it does appear automatically that he would have escaped on that charge as well.
That may be a good assumption, but I'm just making some assumptions.
Okay.
And if you are negotiating with an accused person as a prosecutor in such criminal prosecutions, you don't have to assume that you have 100% case or a case 100% cast in stone. So if you start from a point, and the accused person also gets to a point that you think is reasonable, you have to sometimes trade off. So that's the reason why he started 27.5, he rejected it. 57.5 with 12.5 reparation, rejected it, and insisted that something should be that the amount should be topped up. Then 20 million was added, making at least 90 million Ghana cedis. So in terms of negotiating with that accused person, I think people are making this argument because the thinking is that the court was going to find him guilty. So you had a privilege to know that he was going to find him guilty, so he could have gone higher. That's the assumption. No. So we just look at the probabilities, we looked at the options, and came to a firm conclusion that 90 million was reasonable in the circumstance.
Okay.
Now, issues have been raised with respect to this one, certain as it is being a dangerous president that people may want to rely on that commit crimes and go scot-free because after all, there's no punishment embedded in it. This is not a carte blanche. Atuesent might have argued his case well, might have used lawyers who also conduct his case well, might have also, by the way he also approached the prosecution, able to convince us that reparation was quite reasonable. He doesn't give anyone the lines to say that he's going to do the same thing, come back and be thinking that the state will accept anything. In fact, after negotiating on the 90 million, we insisted that without paying 30 million, that wasn't part of the deal, without paying 30 million down, still, we're not going to agree. And actually, in fact, he paid that money a day before the judgment. So we tried everything possible to also make sure that he also went to some form of I mean, if it's not about physical punishment or anything, he also has gone through some form of punishment. Now, when it comes to what you lose, Samson, you've alluded to it, there are so many limitations placed on him. Now, the goat thief that we are talking about, if that goat thief is a laborer, and he takes advantage of Section 35, if that goat is for the state, and there is a provision in the law that he cannot be a laborer again. Yeah. There too, it's not a punishment to that goat thief. In terms of this amount, it's for the state. So a state may want to negotiate with an accused person, but a goat thief, someone who goes to steal the goat of a private person, that private person is not ready to accept the goat. He may want that person to go into prison. So if you're a prosecutor, you cannot stop it, because the owner of that item is not ready to sit down with the complainant or with the accused person to have the matter sorted out.
All right.
Now, if you are a goat thief or a yam thief, and the yam, as Daniel said, if the yam belongs to the state, and there is this kind of economic loss to the state, you can take advantage of Section 35. So it matters not who is involved. In fact, if you take the case of the quality grain case, which was I think Yasafre sat on that matter. In his judgment, he made allusion to Section 35. And he said he was even surprised that this person did not take advantage of Section 35. If you read the Malamisa case, a similar pronouncement was made when the matter went on appeal, why he did not take advantage of Section 35. So we have two options. Either we decide as a state that when people commit offenses, we go to court, prosecute them, and damn the consequence. We can prosecute them if they are convicted and sentenced to prison custody. They will go. They have don't let us forget. They have the right to appeal.
That's right.
The person go into custody, he will appeal. He may win the appeal. State gets nothing. He may go in, then he may even be pardoned. It has been happening. He may go in, then he comes back to enjoy the booty. But the problem that we have as a state is that we always talk, but we are not ready to talk to security agencies. If Atu Essien had been convicted by the court, and the court had ordered that the state should recover the money from him, that would have been the best. But that one would have been the best only when Atu Essien has some property that we can fall on. If he doesn't have any property, it ends the matter.
Okay.
But if we have information on other cases and they think that, oh, it's me, for example, it's Daniel. Daniel has property A, B, C, Y, Z, and security agencies they are involved and they are also informed, definitely you will know something that you will be holding on to. If you are negotiating with them, you realize that you have property A, B, C, D. Something you know that in that case, you will also be as hard as possible. Because in any event, there's something that we can fall on.
All right.
So we did all this, taking into consideration the facts available, and also having realized that there's a need for the state at times, if need be, look at Section 35. Whether he used 35 or the plea bargain, we do not initiate that process. It is the accused person who initiates. If he initiates and the offer is good, the state may consider it. If the offer is bad, the state will reject it.
Right. And as I heard you after court on the day, you said that you can assure Ghanaians that by the expiration of a particular date where he's supposed to pay some money, if he doesn't pay, you can assure the public that the matter will go back to the court for the court to exercise what it has to do, correct?
Yes. The first payment is supposed to be made on or before 28th April. If on the 28th April, Atu Essien has made 19.999 million Ghana, remaining 1 peswa, Ghanaians should rest assured that the following day, the police will pick him up and the entire amount outstanding becomes payable. If he's not able to pay, the court will go ahead to sentence him.
Oh,
that
no,
one,
but a judge will not sentence him on that. That being the second installment, not being the final installment, which is expected in December 2023. And a court will note that if a substantial amount has been paid, why do you sentence when there is room? And in fact, the third installment is pending, and the final installment is also pending. So wouldn't it be reasonable for a court rather to say, if you have defaulted and you have not paid all by this time, I'm allowing you extra time to do this, rather than say, go to jail, if the money is what we want?
We will object to such a stand by a judge, because the agreement we've had with the first accused presents to the fact that that money ought to be paid on or before 28th of April. So not even a day.
All right.
Added to it.
Okay, thank you. But courts act with reasonableness. Yes.
I have a problem with that provision. And that provision that says that under the section 35, if the accused person defaults, then he would now go to jail or,
he'll be sentenced. And
that is why I asked. You recall that Senior Martin Pebu went to the Supreme Court. This law is 1993.
That's
and
right.
the Supreme Court decision, I believe, is 2016 or 2017. Now, this document that has been signed between the state and Mr. Atuesien, devoid of all the embroidery and the circumstances, is purely a contract.
No, but it's a contract under Section 35 of the Courts Act. And so it is that section that applies, not the ordinary, agreements that you do.
I am coming, Samson. The same understanding was what we had when it came to surety for bails. If you recall what the Supreme Court said in respect of that. You see, before then, the practice was that if you stood surety for bail and the accused person jumps bail, you, the surety, would suffer.
Yeah, you were arrested and then,
And the Supreme Court said once the document is signed, it is a contract
between the state and the accused
person. And the accused person.
So
the surety.
That. Yes, and
the
so
surety.
You enforce that.
And so you enforce it by means of civil procedure. And the Supreme Court went to the extent of striking out that provision in the Courts Act as being unconstitutional.
But this is what this law says.
But isn't
this completely different? Section 35(2)(7) says, where a person convicted under this section defaults in the payment of any money required of the person under this section, or fails to fulfill any condition imposed by the court under subsection 6, any amount outstanding shall become due and payable, and upon failure to make the payment, the court shall proceed to pass a custodial sentence on the accused.
Samson, all that I am saying is that we had a similar provision in the courts, in the
How
code.
Similar?
In terms of the... No, wait. If tomorrow, and I'm not saying this is what will happen, but looking at the situation, it's possible as lawyers. Tomorrow, Mr. Atuesien is not able to bring the money. His counsel goes to the Supreme Court to say that this provision is unconstitutional and relies on the argument in the Martin Pebu case. And it suspends any form of custodial sentence until the Supreme Court determines the matter. Assuming, and it's a possibility, because lawyers, this is what we are paid to do.
So we have spent quite some time, so I think your point is made. You want to say something just
about this point?
Because he said, as and now, they were not sure if Mr. Essien had
so that point is made. What do you want to say in a minute? And then Sule and Mary, please, in a minute, if you can just express what you want to say, so that we take a break, we come back and we tie in with this, the matter of the special prosecutor, which is also about corruption. Yes.
All right, thank you very much, Samson. Let me say that when a trial is conducted under Section 35 of the Courts Act, the trial doesn't come to an end merely because there is a concluded agreement of reparation and restitution. So let me let the public understand that Atuesien's case has not ended.
For him.
It has been held in abeyance. That is why what we just read says that when he defaults in making complete reparation or compensation or restitution, the court may proceed
It's not may, we say
shall proceed
to pass a custodial sentence.
What does that mean? It means that the court still has the case before it until such time.
That's why his passport is taken away from him.
That is it.
And a few other things.
So until he pays the money fully, the case is still pending, kind of. It is in principle pending. It is being held in abeyance. So what the public must understand is that if he finishes paying, now the case ends. If he does not and he defaults, the court may call him and sentence him.
That's right.
So we should not think that anybody is doing anything fishy or anything untoward. Everything that has been done in this case is within the parameters of the law. Okay. And for me as a lawyer, once something is done within the law, I think I shouldn't have anybody to blame.
Thank you. Sule and Mary, a minute. What do you have to say by way of some reaction or concluding statements?
These things are
yes, Sule first.
They are different.
Well, Samson, I think that fundamentally, from all the explanations, perhaps we have to look at the law again. That's number one. Number two is that, yes, I fully followed the submission of the Deputy Attorney General and the points he made that, well, proceeding on the grounds that some of us argue would assume, well, the man was guilty, and we could conclude that he was guilty. But that, in the legal processes, you cannot assume that position until perhaps there is that pronouncement. But again, I think this was quite a case that we all thought was basically straightforward. We were told, well, the banking collapses as a result of all these practices. And then the end of it is that this man took state money, bring the state money. If you're able to refund it, you are free to go. And I think that I'm still quite not satisfied that that is the approach we should use. And if the problem is the law, then we need to look at the law again.
Okay. And some will say, if the problem is the law, we now have a better law, which has just been passed in June or July of 2022, which allows that you can be made to pay money and then take a lesser sentence. And as you find in the OSP Act, the Narcotics Commission Act, they can use you, the state can use you as an asset. Maybe it's a crime that is committed by a whole group, a corruption that's committed by a whole group, and they get one of you. They can ask you, the one person can decide that, look, it's difficult to get all these other people. I am going to help you to get them. In view of that, don't try me, or I'm going to be a witness for you. In view of that, don't try me. Free me, and then let all the others suffer so you get a better process. Yes, Mary.
So for me, something, the fact remains that we are in a system where we want to see a expeditious trial leading to recovery, yes, but there's also punitive sanctions to deter people who want to engage in such activities. We are particularly also worried when we see private interests coming into this space to ensure that they are even enriching themselves more at the expense of the state. The Attorney General or the Deputy Attorney General's submissions are very cogent, yes, but it is not enough, and we continue to call on them to go beyond or delve deeper into some of these issues. Now we have a law that can do this, but then we know that we expect of them very high standards, and we believe that in this instance, they could have done more. And the review of the law is perhaps the ideal thing we are all seeking to see, to ensure that there is punitive sanctioning when the need arises. But also to say that, apart from the punitive sanctioning, we need this recovery to show people that the state is ready to do its work and nobody can get away with wrongdoing.
All right.
Just like that. People enrich themselves at our expense when poverty continues to be perpetuated and entrenched in our society.
So we take a break here. When we return, we'll go to the OSP where we are told that for 16 months they've not been paid salaries, they have difficulties. And so if you see them working the way they are working, They are doing all of that with a salary, and they have challenges in their office and all of that. Some are wondering, this is the office that is getting us a lot of money so far. They have stopped the NDA, crime, so to speak. The 10 million has not been paid. They have stopped it. When you go to the matter with the GRA, they manage to get us some money in that area as well. So what is going on? We'll be right back to deal with that very briefly, and then we zoom in finally to give room for our other JoyNews team to bring us the NDC's national officers election. But there's a question we are asking: the confession of Esiedun Ketia, should it have any implications? We'll be right back.